Please say after me. I.
I, Bilkisu Buhari, do solemnly swear that the evidence I shall give to this committee shall be the truth, the whole truth, and nothing but the truth. So help me God. Honorable Chairman, sir, and honorable members of the committee, standing on all existing protocol. Sir, the Special Duty Legal of the Lagos Directorate received the case file of Idris Okuneye, aka Bobrisky, on the 4th of April, 2024. After the receipt of the case file, my team sat down to come up with the case plan and proceed with the case. That in the course of carrying out the commission, in a bid to curb the mutilation and naira abuse, set up a special task force to look into this offense. And Bobrisky was apprehended in the course of that. Sir, in the case file, the statement of the ex-convict confessed inter alia that Bob Express is not registered with SCUMO, that is Special Control Unit Against Money Laundering, because I'm not aware of it. Ignorance of the law is not an excuse, which informed our decision to charge him for not rendering returns contrary to the Money Laundering Act, Section 6(1), and punishable under Section 19 of the same Act. However, on the 5th of April 2024, we moved a motion for the Honorable Court to hear the matter because it was a vacation matter, and we were granted leave to proceed with trial. Notwithstanding the unequivocal confession of the ex-convict, convicting the essential ingredients in counts 5 and 6 of the charge, and having indicated willingness to plead guilty to counts 1 and 4 of the charge, which has to do with mutilating of the naira currency, the prosecution in total fidelity and conduct its oath and strict adherence to professional practice of not only disclosing exculpatory documents to defense, having received a report of investigation activities from SCUMO, which showed that Bob Express is not a designated non-financial business and profession, decided to drop counts 5 and 6 of the charge in the interest of justice and fair hearing, without any inducement or prompting of any sort from the defense, and in line with the mandate of the Special Task Force Against Naira Abuse. We attached the response from SCUMO. We also attached the charge showing counts 1 to 6. There was no amendment of charge. The dropping of counts 5 and 6 was done in court because the ex-convict elected to plead guilty to counts 1 and 4, which had to do with naira abuse. In any event, counts 5 and 6, which had to do with not rendering returns to SCUMO, showed that it was not the Bob Express, which he used to trade, is not a designated non-financial business and profession. That's what informed our decision to drop counts 5 and 6 in court. An amendment of charges is not alien to practice, particularly sections 216 of ACJA 2015. It is also noteworthy that the alteration made by the prosecution did not contravene any provision of the extant policies of the Commission and its standard operating procedures. We have amended charges severally in court when the need arises. That the steps taken by the prosecution in this proceeding, dropping counts 5 and 6, which is akin to amendment of the charges, can take place at any time before judgment, is not alien, as the Commission has, in numerous instances, had cause to amend, add, or subtract from the body of the counts of the charge preferred against defendants, and this will not be the last. we attached records of proceedings of the court showing how we arraigned the defendant in court. The Honorable, to show that the ex-convict there was no cohort between the prosecution and defense, the ex-convict even appealed the judgment of the court. If there was any interaction or any agreement, he would have gotten what he wanted and he couldn't have appealed. We also have the notice of appeal by the ex-convict attached to our documents. We also attached a copy of the charge, the record of proceedings, and the memo setting up the special task force that investigated the case of the ex-convict. So I want to state categorically that there was no form of financial inducement to any member of the commission, especially the prosecution team, in respect of this matter. All we did was we carried out our duty as regards to our core values of professionalism and the ethics that I took as a legal practitioner to prosecute and not persecute anybody. We are most grateful.
Are you done?
When we were analyzing the case file to prepare our charges, the purport of the charges in the first place was to charge for Naira abuse and mutilation of Naira currency. But then the defendant confessed that Bob Express, we attached his statement wherein he proffered this confession. Bob Express is not registered with SCUMO, Special Control Unit Against Money Laundering. And knowing that we can convict on a confessional statement, we went ahead to include counts 5 and 6 in the charge. But when he elected to plead guilty in court in the morning, and having at the back of our mind that we response from the Special Control Unit Against Money Laundering, saying that the Bob Express that we're charging for not rendering returns is not qualified to be a designated non-financial business and profession as provided under the Money Laundering Act.
Is it clear now? Okay. Do we have any other person? Okay.
Mr. Rotimi Oyedipo, I think there's a bit of a mix-up here. Rotimi Oyedipo isn't the prosecutor who handled this case in court. The prosecutor is here. Belukisu, yes, not Rotimi Oyedipo. So if the committee wants her to make a presentation, she's here, but not Rotimi Oyedipo. She was not the one. But I would like to also... Yes, the prosecutor is here in court. Yes. Thank you.
Charging for 6 counts, but she has explained why they had to drop the money laundering charge. So on that note, dear colleagues, the day is fast spent. I want one of us to move that we adjourn. Okay.
The chairman and the co-chair of the Joint Committee for the investigation of this disturbing allegation of corruption against the EFCC and other government agencies. I stand here today. My name is Michael Nzekwe, the Chief of Staff to the Executive Chairman. I stand to represent him. He sends in his sincere apologies for not being here due to the exigencies of duty that came calling, though he would have wished to be here. The letter of investigation into this very deep and disturbing allegation, we would like to just make this presentation on behalf of the Executive Chairman very quickly. Our attention was drawn to the viral video published by one Martins, Vincent Ute, a.k.a. Verydarkman VDM, wherein Idris Olarowaju, Okeneya, a.k.a. Bobrisky, and ex-convicts, alleged that the officials of the commission received the sum of 15 million naira to drop money laundering counts in charge FRON versus Okuneye Idris Olarowaju. In the same video, the publisher, the Verydarkman, revealed that Bobrisky made this presentation to an undisclosed friend of his, whom he intended to receive a financial support from. Attached here is a copy of the charge we have marked as Enclosure 1. Given the gravity of the offense, which touches on our core value as a commission, it touches seriously on our core value, and we do not take kindly to the integrity of the commission, one of the best all over the world and in Africa, for our integrity to be touched. Given this value of integrity, courage, professionalism, and collaboration, the executive chairman promptly constituted a team to investigate the claim and equally issued a statement through his various social media accounts to that effect. While investigation is still ongoing, the executive chairman received from this honorable house an invitation directing his appearance and the concerned officers of the commission before this honorable committee for an investigative hearing. Upon close scrutiny and analysis of that video that gave rise to this investigative hearing, the commission observed the following: that the published and widely circulated video contained a private conversation between the ex-convict and a yet-to-be-identified individual who, in an attempt to obtain monetary benefit, alleged the compromises and the compromise of the officers of the commission, the Nigerian Correctional Service, a private legal practitioner, Femi Falana, SAN, and a private and Fals, the bad guy. That in an attempt to induce and convince the yet-to-be-identified individual into parting with his money, the ex-convict alleged that the sum of 15 million naira was demanded by the officers of the commission to drop the count of money laundering counts in counts 5 and 6 of the charge sheet, and that he could not transfer the said sum from his account because of the investigation, thereby inferring that the said account was frozen. That at the time he was demanding for this money and claimed his accounts were frozen or under investigation, the commission never, at no time in the course of investigation, placed the account of the ex-convict under post-no debit. His account was never frozen throughout the period of investigation. Whereas the ex-convict mentioned the names of his friends who raised various sums of money and credited same to the account of his brother. The names of the officers of the commission that allegedly collected the bribe were not disclosed by the ex-convicts. Also, the mode, the place, date, and time of the delivery of the alleged bribe, or to an account where it was paid, was not disclosed by the ex-convicts. Arising from the above observation, the commission wishes to state categorically as follows: in view of the prevalent nature of the currency mutilation and abuse of the naira, which has been expressly criminalized by Section 21 of the CBN Act 2027, the commission, in a bid to curb the said offenses and in the discharge of its statutory duty, set up a special task force via a memo by the executive chairman to all its directorates. Now, attached here with is also a copy of the said memo marked as Enclosure 2. As a result of the setting up of this special task force and the vigorous sensitization, investigation, and prosecution, a number of convictions were secured, which has significantly stemmed this dangerous tide of abuse of the naira, to which all Nigerians are witness today. It was in the course of carrying out its mandate that the Special Task Force of the Commission, Lagos Directorate, received intelligence which revealed 4 different videos of gross abuse of the Naira notes perpetrated by the ex-convict, which warranted his investigation and prosecution. That on the 3rd of April 2024, the ex-convict, while undergoing investigation, in his extrajudicial statement, confessed clearly inter alia, Bob Express is not registered as SCUMO, Special Control Unit Against Money Laundering. I'm not aware. Hence the inclusion of count 5 and 6, due to his own confession that Bob Express is not registered. So the prosecutors had to now include all of this and then did a further check on that. Now, in the body of the charge, this was included, wherein the defendant, now ex-convict, was alleged to have failed to submit to SCUMO a declaration of his activity, which is contrary to Section 6.1 of the Money Laundering Prevention and Prohibition Act 2022, and punishable under Section 19 of the same Act, in addition to the substantive offense of tampering with the Naira note as contained in count 4, for count 1 to 4. However, on the 5th of April 2024, notwithstanding the unequivocal confession of the ex-convict, admitting the essential ingredients of in count 5 and 6 of the charge, and having indicated willingness to plead guilty to count 1 and 4 of the charge, the prosecution, in total fidelity and candor to his oath and strict adherence to professional practice of not disclosing documents to their defense, having received a report of the investigation and activities from SCUMO, which showed that Bob Express is not a designated non-financial business and profession, decided to drop counts 5 and 6 of the charge in the interest of justice and fair hearing, without any inducement or prompting of any sort from the defense, and in line with the memorandum of the special, with the mandates of the Special Task Force Against Naira Abuse. We have this also attached here and marked as an Annexure 3. That the Honorable House is invited to note that alteration, amendment, addition of charges is known to law. Very known to law. Particularly Section 216 of the Administration of Criminal Justice Act 2015. It's also noteworthy to note that it is also noteworthy here to note that the alteration made by the prosecution did not contravene any provision of the extant policies of the Commission, nor a standard operating procedure. That the steps taken by the prosecution in proceeding to drop count 5 and 6, which is akin to amendment of the charges, can take place at any time before judgment is not alien, as the Commission has in numerous instances caused charges to be amended. You can see our attachment as enclosure 4. The Honorable House is urged to use this constitutional power to ensure that corruption and other vices are exposed, investigated, prosecuted, and also ensure that patriotic and dedicated officers are not blackmailed, demonized, and demoralized for faithfully serving and carrying out their lawful duties. That the Commission has been consistent in its advocacy, calling on all public with credible information on any alleged act of corruption involving any of its staff to come forward with evidence. This, the public is urged to do responsibly. Short of the ex-convicts and other accusers openly naming the officers of the Commission to whom they allege gave the bribe of 15 million naira in order to induce and influence the dropping of counts 5 and 6 of the charge, bordering on money laundering, it is reasonable to infer that the ex-convict merely made up the story to convince the yet-to-be-identified person he was speaking with in order to obtain financial favor under the pretense by dropping the name of the Commission. We wish to draw the attention of the Honorable House to the fact that the onus of proving this grievous allegation against officers of the Commission rests squarely on the accusers in this case, the ex-convicts and the Verydarkman. It is noteworthy that the Commission extends an invitation to the ex-convict and the Verydarkman to come and assist the Commission in unraveling the identities of the officers of the Commission to whom the alleged bribe of the sum of 15 million naira was paid. Regrettably, Up to this moment, none of them have honored the invitation. While appreciating the seriousness attached to this incident and the noble steps taken by this Honorable House to unravel the truth contained in this allegation in the viral video for the sanctity of the institution and the nation Nigeria, the Commission wishes to assure this Honorable House and the general public that on our part, we are committed to getting to the root of this matter, and appropriate actions will be taken accordingly. In conclusion, the Commission is appealing to the general public to desist from attaching parochial sentiment and unfounded assumption to actions taken by patriotic and dedicated officers in the course of discharging their duties in the interest of the nation. Accept the assurances of the Executive Chairman's highest regards. Thank you.
We were already at a closed section towards the point for chairman of this committee to make summary before this was submission. I would have loved if this submission have come before even the prosecutor. But be as it may, like you already know, we are all here to make sure that justice is served. Secondly, we are all here to make sure that our institutions that are trying their best to put this country in a better shape, just like Mr. President have assured us of the New Hope agenda that we are all in, to make sure that these things go on well. That's why we're all seated here. Thirdly, for me, as a member of this committee, I've already made my submission to chairman. Some of these whole allegations and whatever have been said today is centered on one person, and that is Mr. Okunaya. I don't want to mention the other one you are mentioning. Is he? I don't know him. Even what is written here is he. So I am going by what I think you are looking for. I will send you back to Abia. So he centered on him. And I want to submit this way, that this investigation will have more meaningful impact when we have him on the ground before us. Secondly, to have the alleged person who is in that tune of that conversation, that they were all communicating together on the floor. With all these people, then we'll be able to really see what is really happening, so that they can look into our face and say, this Mr. A was whom this was given to, Mr. B, this was given to. So I will want you to also have yourself relaxed in terms of those issues of dropping count charges or not. It's also on that same Mr. Idris to authenticate. We have heard from every quarter. So, Mr. Chairman, I want to submit that we adjourn to have Mr. Idris on ground, and then with the other counterpart whom they discussed with. We already have Vincent on ground. We have already, all the submissions have been made, so that it will help us to get to the root of this, and then we'll nip it at board. Thank you.
When Oga was talking, he read from his paper. So one thing I know about investigation and when it comes to cases, when there's a suspect, the suspect will be assigned an IPO. The IPO is the one that investigates the case and then makes a report. Now, what I'm saying is it is possible that the IPO was the one that actually received. Now, in order to know this, the account number that he used to collect money from, the person that reported to me, is a Kuda bank account and his brother's account. That account number needs to be investigated. The money that came into it, the money that left it. Not just that, the money that was withdrawn, because sometimes, we dey show office and law sometimes, and we don't fit transfer money to them, they don't agree, right? So, it's possible that they withdrew money via POS or they withdrew cash and they paid. So the people that should be there, sorry to not suggest, the person who I think should be there are the direct IPOs that reported to their organs on everything. That's what I think. Thank you, sir.
that it was based on the confession of the same, whether if you can get money today and transfer to this point, at this point, you trace it to that point, you trace it to the final point. Even if it is withdrawn cash, you will also know that it is withdrawn cash. So, Chairman EFCC, who is represented here, you should take note of that. We are taking note too. We have powers to scrutinize those accounts. And you can be sure, like I said earlier, that we are going to trace this, the movement of these monies to the final destination. That is one. Secondly, there is the person who actually recorded that video, that audio. In our next sitting, should be here. We need that person who did that recording. We need to have his number, the number that was called, and the number that called the number. This time around, phone numbers are registered. We'll be sure that the number that made the call belongs to Bobrisky. We'll also be sure that the number that received the call is here. We'll also approach the network providers for us to be sure that it is not artificially generated. So, having said that, to the man in charge of our correctional facilities, if you have listened carefully to what the man who is representing the chairman said, he said that immediately they saw that viral video, they set up a team to investigate what happened and all that. So I don't know if you set up a team or if it is based on the team you set up that you arrive at the suspension of two of your colleagues, the man in charge of the medium and the man in charge of the maximum. Both of them were suspended. So I also don't know if you have set up a team, you have your own internal disciplinary mechanism of how to know whether these things are true or not. So what we are doing here, like our colleagues are saying, is we want justice. If these people did not commit anything and you suspend them, you have not also served justice. And if you have suspended them, invariably, what it means is that you are confirming the allegations. You are confirming that these people actually took money and took these people to this and that. Yes. So what I'm saying is that we have to look at this whole thing critically and be able to come up with the real truth in this matter. So on that note, I will invite our colleagues to move that we adjourn